Welcome to CM Guide podcast series. Today we're taking a deep dive into something, well, pretty crucial if you're involved in construction in Australia. We're looking at the unique world security of payment legislation, specifically up in the Northern Territory. And this isn't just dry legal stuff. It's really about ensuring everyone, contractors, subbies, even principals, get paid fairly and, importantly, on time. So our mission for you in this deep dive is to sort of unpack the Northern Territory Act. We want to understand its unique approach, how payment claims and disputes actually get resolved, and what happens if things end up going to court. Think of it as getting you informed quickly, thoroughly, and maybe with a few surprises thrown in.
Yeah, and just to kick us off, it's worth highlighting straight away that the Northern Territory really is quite distinct. Unlike most other places in Australia, its legislation still follows what's often called the West Coast model. And this approach, it provides for an interim payment system leading to a really rapid adjudication process. That really sets it apart from jurisdictions like, say, New South Wales or Victoria.
Okay, the West Coast model. Let's unpack that a bit. You're saying it's quite different. What are the key things that make the Northern Territory's construction contracts, Security of Payments Act, 2004, the NT Act, let's call it, stand out compared to the others?
Well, what's really interesting, I think, is the flexibility it offers. First off, unlike other Aussie acts, claims can be made both up and down the contract chain.
Up and down. So a principal could claim against a contractor, too.
Exactly. Or contractor against principal. It balances things out. And second, there's no requirement for a payment schedule before a respondent can make submissions in an adjudication.
Ah, okay. So less paperwork up front for the respondent.
Pretty much. It streamlines their side. And crucially, there's also no limit on what they can actually put in their adjudication response. They can bring up new reasons or arguments.
Wow, okay. That sounds like a big difference compared to the East Coast model we often hear about. So besides that flexibility, what else makes the NT Act unique?
Well, another point is that all adjudicators in the NT must be registered, so there's a qualification check. And here's a really interesting one. The parties can sometimes select their own adjudicator, or at least the body that appoints them.
Really? Choose your own adjudicator? That's unusual.
It is. You don't see that level of party control often.
Yeah.
And the adjudicator themselves, they adopt what's called an evaluative approach, meaning they aren't strictly tied just to the documents put in front of them. They can, take a broader look. They also have wider powers, things like allowing lawyers in conferences, hiring independent experts, even arranging for tests on the actual works. It's a more active role.
So it sounds quite flexible, almost a bit like a mini trial in some ways. But hang on, before we go deeper there, how does a payment dispute actually, crystallize? How does it become official under the NT Act? And what about the original contract? Does the Act just ignore it?
That's a really important point, actually, because the NT Act retains the primacy of the contract.
Primacy of the contract, okay.
Yeah, what that means basically is your actual construction contract is still the main document. The Act works alongside it or fills gaps, but it doesn't just steamroll over it when it comes to how you make a claim or when a dispute technically arises. Either party can kick off an adjudication for a payment claim. And it's not just limited to claims for, say, work done. A principal, for instance, can use it for things like liquidated damages or disruption costs or defects.
Okay, so it covers a pretty broad range of money issues then.
It does. It keeps the scope wide.
That's crucial to understand, that the contract still leads. Now, are there specific clauses that the NT Act actually bans from contracts? Or maybe things it automatically inserts even if you don't write them in?
Yes, definitely. It's a bit like the UK system in some ways. The Act prohibits pay-when-paid clauses.
Ah, the classic I'll pay when I get paid scenario.
Exactly, that's out. It also stops contracts setting payment terms longer than 30 working days after a claim. That's key for cash flow. And beyond those bans, the Act sort of implies several provisions into contracts. It covers things like how you vary terms, the contractor's right to be paid, progress payments, claim procedures, payment timing, interest on late payments.
Wow, okay.
Ownership of goods, what happens with unfixed goods if someone goes insolvent, even how retention money is handled. It's quite a safety net.
That sounds incredibly comprehensive. So with all that in place, what's the stated goal of adjudication under this act, and how informal is it really meant to be? Is it supposed to feel like court?
No, not really. The Act explicitly says the aim is to determine disputes fairly, but also as quickly, informally, and cheaply as possible. Some court decisions have even called it rough and ready.
Rough and ready, I like that. So speed is key.
Speed and practicality. And remember how respondents can raise new reasons in their response? That's quite different from most other acts. It's often seen as, well, fairer and more practical, especially for complex claims where the adjudicator needs a more judicial perspective. But, of course, procedural fairness is still vital. The adjudicator has to give the claimant a fair shot to respond to any new issues raised.
Okay, so the adjudicator's role sounds really significant. You mentioned judicial perspective and earlier analogous to an inferior court. What does that actually mean for challenging their decisions? You hear about jurisdictional error. Is that the only way in? It sounds like a high bar.
It is a high bar, and this is where it gets legally quite interesting. Under the NT Act, the adjudicator is basically weighing up the evidence on the balance of probabilities, what's more likely true than not about what happened under the contract. The process does look a bit like a court process. And yeah, the role is seen as similar to an inferior court, not just an admin tribunal. So the scope for challenging on jurisdictional error is very narrow. Think of it like this. The adjudicator has a set playing field defined by the Act. Jurisdictional error happens if they step completely off that field or try to do something while on the field that the rules simply don't allow them to do.
So making a mistake within the rules isn't enough.
Generally, no. They have the power to decide questions of law, even if they get it wrong, as long as that error doesn't take them outside their proper jurisdiction. Understanding that difference is key to knowing when a court might step in.
Right. Given that framework, can you walk us through the practical steps? How does a party actually make a payment claim and get it into adjudication? What's the pathway?
Sure. So under the NT Act, a payment claim is defined pretty broadly. It's basically a claim under the contract, contractor versus principal or vice versa, about performance or non-performance. A payment dispute then arises if the amount claimed isn't paid by the due date, or if the claim gets rejected or disputed, or maybe if retention money isn't returned when it should be. To start adjudication, the claimant needs to put together a written application. This has to be done within 65 working days of the dispute arising.
65 working days. Okay.
Yeah, and they serve it on the other party, any other relevant parties, and either the adjudicator they've chosen or a prescribed appointer body. The application needs to follow the regulations, include contract details, the payment claims, and all the supporting info and documents they're relying on. Oh, and a party can pull out before an adjudicator is appointed, or even after, unless the other side objects and the adjudicator thinks they have a good reason to want a decision.
Okay, and what about the other side? How does the respondent reply to that application?
They get 15 working days from receiving the application.
15 working days? That's not long.
No, it keeps the pressure on. Within that time, they prepare a written response and serve it back on the applicant, other parties, and the adjudicator, or appointer. The response has to detail why they reject or dispute the claim and include all their supporting info. They don't need to repeat stuff the applicant already provided, though.
And how do these adjudicators actually get appointed? You mentioned parties can sometimes choose or use an appointer. What if there's a conflict of interest?
Right, so if the application goes to one of the prescribed appointer bodies, they have 5 working days to appoint a registered adjudicator. They might chat with the parties first about who has the right qualifications. If the appointer doesn't manage it in time, the registrar that's a government official overseeing the process can step in and appoint someone.
Yeah.
Now, conflict of interest is important. An adjudicator is disqualified if they have a material personal interest in the dispute, the contract, or the parties.
Material personal interest.
Yeah. If they realize they're disqualified, they have to tell everyone, including the registrar. A party can also ask the registrar to declare an adjudicator disqualified. If the registrar agrees, the appointment ends, but the claimant can usually start a new application. If the registrar disagrees, the adjudicator stays on.
It seems like a pretty well-defined system for appointment and conflicts. So once they're appointed and clear of conflicts, what powers do these adjudicators have during the actual adjudication? Do they use them often?
They have quite broad powers.
Yeah.
They aren't bound by strict rules of evidence, like in a court. They can basically inform themselves however they see fit. To get information, they could, say, arrange for testing of the works or hire an expert to investigate something unless all the parties object.
So they can be quite proactive.
They can be. But in reality, because those timelines are so tight, 10 working days usually, maybe 15, they tend not to use these inquisitorial powers that much. There just isn't always time. They can ask the registrar for more time to make their decision, but importantly, they have to ask before the original deadline expires.
Right. Can't ask after the clock runs out.
Exactly. They can also handle multiple disputes between the same parties or even different parties on the same project at the same time, as long as it's fair. And if a party just fails to make a submission or doesn't cooperate, that doesn't stop the adjudicator from making a decision. They can also set their own procedures if the regulations don't cover something specific.
Okay, so how does the adjudicator actually reach their final decision, their determination? What are the requirements there?
Well, firstly, they must dismiss an application without deciding the merits if certain conditions aren't met. For example, if it's not actually a construction contract under the Act, or the application wasn't prepared properly according to the rules.
So basic jurisdictional checks first.
Right. Or if the dispute is already part of another adjudication or a court has already ruled on it. They also have to dismiss it if it's just impossible to make a fair decision, maybe because it's too complex or there genuinely isn't enough time. But assuming none of those apply, they then have to determine, on the balance of probabilities, if any party owes money or needs to return security. They have to specify the amount, any interest, and the date it's due. They can overlook minor technical flaws in the application if it substantially complies and doesn't prejudice the outcome.
And can they include things like liquidated damages?
Yes, if the contract allows for them, they can assess and include LDs in the determination. Now, if the adjudicator doesn't dismiss or determine the application within the time frame, usually 10 working days after the response, plus maybe a 5-day extension for fairness, it's treated as dismissed automatically.
Okay, automatically dismissed if time runs out. And once they do make that determination, what does the actual document need to include? And how legally binding is it?
The determination itself must be in writing, follow the regulations, and importantly, give reasons for the decision.
Reasons are key.
Absolutely. It needs to state clearly who pays what by when, or what security gets returned by when. If there's confidential info, that needs to be marked so it's not published publicly. A copy goes to all the parties and also to the registrar. And the critical point is, this determination is binding on the parties.
Binding even if there's other legal stuff happening, like arbitration or court.
Yes. Even if other proceedings about the same dispute have already started, the adjudication determination is binding on the parties involved in the adjudication.
Okay, so it's binding. But what if the party who's supposed to pay just doesn't? What happens then? Are there teeth?
Oh, yes, there are definitely teeth. If the determination says a principal has to pay and they don't comply, the contractor can give them written notice saying they intend to suspend work.
To suspend work, that's a big step.
It is. The notice has to give at least 3 working days warning and specify the suspension date. If the money still isn't paid by then, the contractor can legally stop work. They can keep work suspended until 3 working days after they finally get paid. And during that suspension, the contractor isn't liable for any losses the principal suffers because of the stoppage.
And they keep their contract rights.
Yep, they keep all their rights under the contract, including the right to terminate if the contract allows. Plus, the party owed the money can enforce the determination through the courts. They get a certified copy of the determination from the registrar, file it in a competent court with an affidavit saying how much is still unpaid, and bang, it's treated like a court judgment.
So you can use the court system to chase the debt.
Exactly. It becomes enforceable just like any other court order. And if the determination didn't specify an interest rate on the overdue amount, a prescribed rate automatically applies.
Right, sounds like solid enforcement mechanisms. What about the costs of the whole adjudication process? Who pays for that? And how does it interact if parties do have other court or arbitration cases going on?
Generally, each party pays their own costs for the adjudication itself, like preparing their submissions.
Okay, bear your own costs.
Usually. However, if the adjudicator finds that one party acted frivolously or vexatiously or made completely unfounded arguments and caused the other party to incur unnecessary costs.
Ah, so bad behavior can be penalized.
Yes, in that case, the adjudicator can order the misbehaving party to pay some or all of the other side's costs. They have to give clear reasons for doing that, though. The adjudicator themselves is entitled to be paid for their work, of course. They can even hold back releasing their decision until their fees are paid.
Right, makes sense.
The parties are jointly liable for the adjudicator's fees, usually split 50-50, but the adjudicator can decide on a different split, if appropriate. They might also ask for deposits up front as security for their costs. As for other legal proceedings, parties absolutely keep their right to go to arbitration or court over the underlying dispute. The adjudication provides an interim decision. If court or arbitration starts while an adjudication on the same dispute is already underway, the adjudication must continue, unless every single party agrees in writing to stop it.
So the adjudication takes precedence in that sense.
It continues alongside, providing that quick interim outcome. And evidence used in the adjudication generally can't be used in those other proceedings, except for specific review applications we'll talk about. Importantly, any arbitrator or court dealing with the construction contract later must take into account any payments already made under an adjudication determination. They can make orders to adjust things, like ordering repayment if the final decision differs.
Okay, that clarifies the interaction. Let's circle back to the adjudicators themselves. We know they need to be registered. What are the specific regulations around their appointment, qualifications, and oversight?
Right. The NT regulations list 8 specific organizations as prescribed appointers. These are the bodies that can officially appoint adjudicators. They're all nonprofit organizations. To qualify to be an adjudicator, you generally need a relevant degree. Think architecture, building, engineering, quantity surveying, or law from an Aussie uni or equivalent.
Or experience.
Or experience, yes.
Yeah.
You might qualify through membership in certain professional bodies or by being a registered building contractor. But critically, you need at least 5 years' experience in either administering construction contracts or resolving disputes related to them. And you also have to complete a specific training course approved by the registrar.
So qualifications, experience, and training.
Exactly. The registrar has the power to register people, renew their registration, or even cancel it if they're no longer eligible, aren't competent, or engage in misconduct. There's a public register kept of all adjudicators. Adjudicators have reporting duties to the registrar, and the registrar has to make the outcomes of determinations publicly available, though with confidential bits removed. Oh, and adjudicators get some legal protection. They generally can't be sued civilly or criminally for things they do in good faith under the Act, but that doesn't protect them from, say, contractual liability they might have.
Okay, good to know about the oversight and protection. Now, with all these decisions being made, sometimes quite quickly, what happens if someone thinks the adjudicator got it fundamentally wrong, especially on dismissing an application? Are there avenues for review?
Yes, there is a limited right of review, but only for a specific situation. When an adjudicator dismisses an application without actually determining its merits, those dismissals we talked about earlier for lack of jurisdiction or complexity.
Okay, so not a review of the merits decision itself.
Correct. Just the decision to dismiss before getting to the merits. That review application goes to the Northern Territory Civil and Administrative Tribunal, or NTCAT, used to be the local court, but now it's NTCJAN. If NTCAT sets aside the dismissal and sends it back, the adjudicator then has 10 working days to make a proper determination. NTCAT also handles reviews of the registrar's decisions about adjudicators, like refusing to register someone or canceling a registration or deciding on disqualification.
Right. Now, this is where it gets really fascinating for me. We keep coming back to this idea that challenging the actual merits determination is tough because the adjudicator is like an inferior court. How have the actual courts interpreted this? What have the key rulings said about jurisdictional error and challenging these determinations? This seems like the crux of it.
It really is.
Yeah.
And the courts have grappled with this quite a bit. The core principle remains. The scope for judicial review is very narrow because the adjudicator's role is quasi-judicial. Jurisdictional error acting outside authority is the main way in. There have been some really significant cases shaping this. For example, A.J. Lucas Operations v. Mac-Attack Equipment Hire. The NT Court of Appeal confirmed the Supreme Court can review determinations despite clauses in the Act trying to limit reviews, but only if the error goes to jurisdiction. They said an error in interpreting the Act could invalidate a determination if it led the adjudicator outside their jurisdiction. They also looked at errors about jurisdictional facts, like was there actually a valid payment claim to begin with? If the adjudicator's decision on that was unreasonable or based on misinterpreting the Act, that could be grounds for review.
Okay, so misinterpreting the Act can be jurisdictional error if it's fundamental.
Exactly. Then there was K&J Burns Electrical v. GRD Group, New South Wales. Justice Southwood really drilled down into jurisdictional error, listing categories like misunderstanding the function, failing to meet an essential condition for jurisdiction, or fundamentally misconstruing the Act. He stressed that the adjudicator's satisfaction that the criteria are met has to be both reasonable and based on a correct understanding of the law. That understanding is a jurisdictional fact.
So the foundation has to be legally correct.
Precisely. Later cases confirm things like the existence of a payment dispute is a jurisdictional fact, Department of Construction v. Urban and Rural Contracting. But it's not always clear-cut. In Atsys Plumbing v. Option Group, the court found the adjudicator did have jurisdiction to decide if a contract existed and what its terms were, acting reasonably. Other important rulings. Briarty v. Guello said you can't just reapply for adjudication of the exact same dispute if you withdrew the first one. CH2M Hill v. ABB clarified that failure to give adequate reasons can void a decision, but you can adjudicate on issues previously decided if it's part of a different payment dispute. ABB v. CH2M Hill confirmed a payment claim must comply with the contract terms to be valid. James Engineering v. ABB established that failing to consider a valid set-off claim is jurisdictional error. It's a constantly evolving area based on these precedents.
That's a complex tapestry of case law. What about procedural fairness or natural justice? You mentioned it earlier. Is that treated as jurisdictional error, or is it a separate way to challenge a determination?
That's another interesting legal point. There's some debate whether denial of procedural fairness is a type of jurisdictional error or a separate ground for review entirely. But in practice, it's generally treated as a distinct basis to challenge a decision.
And does any small breach invalidate the decision?
Not necessarily.
Mm-hmm.
A breach of natural justice generally won't invalidate the decision unless it was material, meaning it could realistically have made a difference to the outcome. Although it's often very hard for the party who benefited from the breach to prove it made no difference.
So the courts take it seriously. Any examples?
Yes, several. In Zerpe Holdings v. Brookfield Multiplex, a breach was found, and because they couldn't show it didn't affect the decision, the determination got quashed. Similarly, in the big NPEX v. JKC case, an adjudicator's determination was overturned, partly because a decision was made on a particular point without asking the parties for submissions on that specific point first.
Deciding something out of the blue.
Exactly. And in Hall Contracting v. McMahon, there was substantial denial of natural justice, because the adjudicator decided the case on a basis that neither party had actually argued for. The court specifically said you can't really distinguish between an adjudication just for cash flow versus one deciding final rights when you're assessing if natural justice was denied. Fairness is fairness.
So procedural fairness remains a critical check, even within this fast-track system. Okay, let's zoom out. Looking at the big picture, how effective has the NT Act actually been? Do the numbers tell a story?
Well, the Act mandates an annual report on its operation, which is useful. The latest one, for 2022-2023, gives us some figures. Over the last 5 years, there's been an average of about 15 adjudication applications per year.
15 a year? That doesn't sound like a huge number.
No, it's relatively low compared to, say, New South Wales or Queensland. Out of those applications, there were about 9 actual determinations made per year, on average. In that 2022-2023 year specifically, adjudicators awarded a total just over $22 million. The average fee for an adjudicator was around $16,900.
$22 million awarded is significant, though.
It is. It shows the system is being used to recover substantial amounts. But the overall stats suggest that, despite its unique features and having 88 registered adjudicators ready to go, the NT Act perhaps sees lower uptake compared to security of payment laws in other major Australian jurisdictions. It's effective when used, but maybe not as popular.
So wrapping this up for our listeners, what's the key takeaway? The Northern Territory's approach. It clearly aims for speed and informality in resolving payment disputes. But underneath that is this really complex legal framework, shaped by court decisions, especially around that very narrow scope for judicial review. It really highlights that constant tension in construction law between getting cash flowing quickly and ensuring absolute fairness and correctness. It definitely gives you a sense of how powerful these adjudicators are in the NT and how vital it is to get your claim or your response right the first time, because challenging it later seems incredibly difficult. A surprising balance, really. Before you go, please don't forget to share, like, or subscribe. Also have a look at other episodes and visit CM Guide website for better insights on this topic.